Supplementary list. Item 2, first of the 77 of 2023 along with item 3 and 4.
ये 44 का जो है ना LCR First appeal number 44/23 पर सब पे पेरेंट्स लिखिए This appeal has been filed against the judgment dated 29/9/2022 and decree dated 11/11/2022 passed by the Court of Learned Civil Judge within bracket Senior Division bracket close Subdivisional Court Chandil in original suit number 35 of 2012, whereby the suit has been decreed in favor of the plaintiffs by declaring sale deed number 1420 dated 3/3/2021 as 2021 तो नहीं होगा ये आपका मेमो ऑफ अपील में क्या लिखा है गलत लिखा है सेल डीड नंबर 1240 dated 3/3/2011 executed by defendant number 2 in favor of defendant number 1 as null and void. Consequently, the defendants are the appellants before this court. आराम से बैठ जाइए हम बहुत आराम से लिखाएंगे just have a seat and if you want to go anywhere आज तो हम I'll just give only the concludes plain written statement the issues decided and then I'll रिकॉर्ड योर सबमिशंस, देखते हैं कितना देर तक होता है. 1 घंटा तो जरूर दिखाएंगे. The title suit number 35 of 2012 was filed for the following relief. Quote में डालिएगा, that it be declared the deed of conveyance within bracket sale deed, bracket close number 1420 dated 3/3/2011, executed by defendant number 2 in favor of defendant number 1, is forged, fabricated, without consideration and void ab initio, and the defendant number 1 has not acquired any interest in the suit premises. Roman 2, cost of suit. Roman 3, any other relief or reliefs. The schedule of the property is part of the schedule of the property is part and parcel of land measuring 150 decimal under Boza Dobo, Thana number 331, Halka number 2, within PS Chandil, District Sarikela, Kharsawa, under District Sub-Registry Office, Sarikela. The suit was filed by 3 plaintiffs, namely Krishna Singh, Sudama Singh, and Bhola Singh, all sons of Taraknath Singh. And the plaintiff number 1 was represented by the power of attorney holder. Plaintiff number 1 claimed to be the attorney holder on behalf of plaintiff number 2 and 3 also. The defendant number 1 is High-Tech Heritage Limited. And defendant number 2 is Lala Vivek Prasad. So far as defendant number 3 is concerned, he is Rameshwar Singh, son of Radha Krishna Singh. And defendant number 4 is Vijay Kumar Singh. it was the specific case in the plaint that the suit land described in the schedule stood recorded jointly in the name of Jogeshwar Ram and Algu Ram in Survey Khatiyan of the year 1964, stated to be their self-acquired property. The plaintiff claimed that Jogeshwar Ram was the own uncle of the plaintiffs and Algu Ram was the brother-in-law, within brackets Saru, of Jogeshwar Ram. Semicolon. Jogeshwar Ram died issueless on 16/11/2000. His wife died in the month of August 2000. Algu Ram died issueless on 20/1/1996, and his wife Dukni Devi died on 27/7/2001. The aforesaid facts has remained undisputed during the course of hearing. Correct? Is that correct? इसमें कोई dispute नहीं है ना अभी तक? एकदम ध्यान दीजिएगा, इधर उधर फोन पे मत लगिए। हाँ, बैठ जाइए।
कोर्ट के अंदर हम कभी फोन उठाते नहीं।
सही है। It was further case of the plaintiff that Jogeshwar Ram and Algu Ram remained in peaceful possession and they cultivated the suit property. The total area of suit land was 150 decimal. And Jogeshwar Ram and Algu Ram acquired, owned and possessed 5 acres 10 decimal, which included the suit land. The total area which was belonging to Jogeshwar Ram and Algu Ram was 5.10 acres, falling under Khata number 9, plot number 1198, 1199, 1204, 1205 and 1206. It was their case that the name of Jogeshwar Ram was also mutated in the concerned Anchal, which was to the extent of entire land of 5 acres 10 decimal, including the suit land, and the rent with respect to the suit property, and the rent was paid to the government till 2011. It was their further case that plaintiffs and Yogeshwar Ram were deciding jointly, and Yogeshwar Ram became old. Therefore, he executed a power of attorney on 8/11/2000 in favor of the plaintiff Krishna Singh, empowering him to manage the entire land. And since then, the plaintiffs were having absolute right, title, interest, and possession over the entire land. Their further case was that prior to death of Algu Ram, the further case of the plaintiff was that Algu Ram, prior to his death, gave his right and possession over the Sut land and other land to late Yogeshwar Singh, by executing a Panchnama in that regard, and consequently Yogeshwar Ram became the absolute owner of the land, which was earlier jointly recorded in the name of Algu Ram and Yogeshwar Ram. The cause of action of the suit arose when the plaintiff came to know that a letter dated 9/6/2012 was issued on behalf of the defendant number 1 in demarcation case number 1 of 2012-13. The said letter was issued by the circle office, to which the plaintiff responded, and ultimately it was followed by a few more communications. And during this, the plaintiff applied and obtained certified copy of the deed of conveyance number 1420 dated 3/3/2011, executed by defendant number 2 in favor of defendant number 1, and also sale deed number 5889 dated 10/11/2010, executed by defendant number 4 in favor of defendant number 2 with respect to the same property. And further, the plaintiff also obtained the certified copy of the power of attorney, which was a deed dated 21/10/2010, executed by defendant number 3 in favor of defendant number 4. the case of the defendant, the plaintiff further stated that on 30/6/2012, the defendant number 1 and 2 threatened the plaintiff to dispossess them from the suit property. And when the plaintiff denied to leave the possession over the suit land, the cause of action arose. It was the specific case of the plaintiff that defendant number 2 had no right to execute the deed of conveyance number 1420 dated 3/3/2011 and hence the said sale deed was not binding upon the plaintiffs. It was also asserted in the plaint that defendant number 3, through his attorney, defendant number 4, had no right to transfer the suit land by sale to defendant number 2. And that the defendant number 3 had no right to execute the power of attorney in favor of defendant number 4. It was further case of the plaintiff that prior to execution of the aforesaid documents, the defendants were fully aware of the fact that the suit property belongs to the plaintiff, but they fraudulently obtained and executed forged and fabricated sale deeds for the purpose of the wrongful gain and to grab the property of the plaintiff. It was also asserted that the suit was barred for non-joinder and misjoinder of parties. The further case of the plaintiff was that there has been no partition between Jogeshwar Ram and his 3 brothers, namely Taraknath, Bajnath and Balmaki. ये है ना? Their name has not been mentioned in the plaintiff. Amongst his 3 brothers का name क्या? Because the property was the self-acquired property of Jogeshwar Ram and Algu Ram. It was further asserted that Rameshwar Singh, the defendant number 3, was not the nephew of Algu Ram, and he is neither directly nor indirectly related with Algu Ram or Jogeshwar Ram or with any of their family members. And thus it was asserted that the defendant number 3 fraudulently executed power of attorney in favor of defendant number 4. It was also stated that Algu Ram were 2 brothers. The other one was Jhagru Singh, who had also died. And thus the plaintiff categorically disputed the relationship of defendant number 3 with Algu Ram or even Jogeshwar Ram, and therefore asserted that defendant number 3 had no right to execute any power of attorney with respect to the properties of Jogeshwar Ram slash Algu Ram in favor of defendant number 4. According to the plaint, the cause of action to file the suit arose on 3/3/2011 when defendant number 2 illegally executed the impugned deed of conveyance within bracket sale deed in favor of defendant number 1, and also on 3/6/2012 when the defendant number 1 refused to write any deed of disclaimer, and on 3/6/2012 when the defendant number 1 and 2 threatened to dispossess the plaintiff from the suit land, and also on 13/6/2012 when the Anchal Adhikari issued notice to the plaintiff seeking demarcation of the suit land. The perusal of the plaint reveals that although the plaintiff stated in paragraph 13 that the deed of conveyance, that is sale deed dated 3/3/2011, executed by defendant number 2 in favor of defendant number 1, was preceded by another sale deed number 5889 dated 10/11/2010, executed by defendant number 4 in favor of defendant number 2 on the strength of power of attorney executed by defendant number 3 in favor of defendant number 1, defendant number 3 in favor of defendant number 4, but no relief was sought for in connection with the sale deed number 5889 dated 10/11/2010. And as per the plaint, the cause of action arose firstly on 3/3/2011 when defendant number 2 executed the sale deed in favor of defendant number 1. Through the plaint, the plaintiff had challenged the relationship of defendant number 3 with that of Algu Ram, and had claimed that defendant number 3 was neither related to Algu Ram nor was related to Jogeshwar Ram. However, during the course of hearing, it is not in dispute that defendant number 3 was not related to Jogeshwar Ram in any manner whatsoever. The dispute apparently relates to relationship of defendant number 3 with Algu. The defendant number 1 had filed the written statement stating that the suit was barred by limitation, barred by the provision of specific relief act, estoppel, waiver and acquiescence. And was bad for non-joinder and misjoinder of necessary parties. It was stated that all the legal years of late Balmiki Singh were not made parties. इसका कोई relevance नहीं है ना वाल्मीकि सिंह के legal years का वाल्मीकि सिंह के legal years का तो कोई मतलब नहीं not necessary
Valmiki Singh is just a brother of.
That's right.
One of the brothers of the
One of the brothers of.
That's right. A specific stand was taken that defendant number 3, Rameshwar Singh, was wrongly made as pro forma defendant, though the relief was claimed as against defendant number 3. It was also asserted that the plaintiffs had no locus to file the suit as their father Taraknath Singh was still alive. It was the specific case of the defendant number 1 that Alguram died issueless, leaving behind his brother Radha Krishna Singh, who inherited half share of the land under Khata number 9, Moza Dobo, and after his death, the only son of Radha Krishna Singh, namely Rameshwar Singh, the present defendant number 3, had inherited the same and came in exclusive possession of the property. The defendant number 1 admitted that Alguram was in separate possession of his half share, and also that the land was jointly recorded in the name of Jogeshwar Ram and Alguram, but before their death, they were in separate possession of half share The defendant number 1 also asserted that the plaintiff never resided with their uncle Yogeshwar Ram jointly under the managership or treating Yogeshwar Ram as karta. It was stated that the power of attorney, if any, dated 8/11/2000, issued by Yogeshwar Ram in favor of the plaintiff Krishna Singh, was forged and fabricated to manage the entire land and transfer if needed, and file suit, etc., is forged and fabricated. The defendant also denied execution of Panchnama and denied that Alguram had given his right, title, interest and possession over the suit land to Yogeshwar Ram, and for that purpose the Panchnama was executed. It was alleged that the Panchnama by itself was a forged and fabricated document, and otherwise also it was not admissible in evidence. It was the specific case of defendant number 1 that Alguram was in possession of half of his land till his death, and after his death it devolved upon his brother Radha Krishna Singh, and after death of Radha Krishna Singh it devolved upon the pro forma defendant number 3, who continued to remain in possession of the same till he transferred it to the defendant number 1. Through his power of attorney, defendant number 4. It was also stated in the written statement that defendant number 2 had purchased the suit land from the defendant number 1 through his legally constituted attorney, namely Lala Vivek Prashad, within bracket, defendant number 2. By virtue of registered sale deed bearing 5889 dated 10/11/2010 on payment of valuable consideration to the defendant number 1, and the land was delivered to defendant number 2, who came in possession of the land and was paying rent after mutation. The defendant number 2 then transferred the land to defendant number 1 on receipt of valuable consideration and delivered the possession to defendant number 1 on payment of to defendant number 1, and since then the defendant number 1 was in possession of the same on payment of rent. It was stated that the defendant number 3 had full right to appoint attorney to transfer the suit land, and it was denied that the sale deeds were forged and fabricated. It was again stated that the power of attorney executed by Jogeshwar Ram lost its force on account of death of Jogeshwar Ram. And that there was no cause of action to file the suit, and the suit was liable to be dismissed. So far as defendant number 2, 3 and 4 are concerned, they also filed written statement in the same line as that of defendant number 1, by asserting that after death of Algu Ram, his half share of the property devolved upon his brother, namely Radha Krishna, who died leaving behind his only son, Rameshwar Singh, within bracket defendant number 3, who came in possession of half share of the land belonging to Algu Ram as the owner of the property belonging to Algu Ram. And therefore, all the transactions made by defendant number 3 were valid. It was also asserted that the defendant number 2 purchased the suit land from the defendant number 3 through his legally constituted attorney, namely Lala Vivek Prasad, by means of registered sale deed bearing number 5889 dated 10/11/2010 on payment of valuable consideration, and the possession of the land was also delivered to defendant number 2 after purchase, and the name of defendant number 2 was also mutated, who paid rent to the state, and thereafter defendant number 2 transferred the land to defendant number 1 on receipt of valuable consideration coupled with delivery of possession to the defendant number 1, who continued to remain in possession.
Defendant number 2 purchased from defendant number 3 लिखा है 4
But defendant number 4.
डिफेंडेंट नंबर 3 से परचेज नहीं किया, डिफेंडेंट नंबर 3 ने पावर ऑफ अटॉर्नी दिया है बाय डिफेंडेंट।
Answering defendant कौन हुआ? रामेश्वर सिंह. रामेश्वर सिंह is defendant
Power
number
of attorney
पावर
holder.
ऑफ
power
अटॉर्नी
of attorney.
इन फेवर ऑफ डिफेंडेंट नंबर 4।
एक सेकंड, लेट मी जस्ट क्लैरिफाई दिस. ये जो है डिफेंडेंट नंबर 2 परचेज द सूट लैंड फ्रॉम द डिफेंडेंट नंबर
4 थ्रू पावर ऑफ अटॉर्नी ऑफ डिफेंडेंट नंबर 4।
from defendant number 4
परचेज फ्रॉम 4 थ्रू पावर ऑफ अटॉर्नी
through power of attorney of defendant number 3 who was Lala Vivek Prasad.
डिफेंडेंट नंबर 3 रामेश्वर
Lala Vivek Prasad
Is it
He is the power of attorney holder.
No.
रामेश्वर
Rameshwar Singh is power.
ये Lala Vivek Prasad
लाला
He is
विवेक
the
प्रसाद इज द
first purchaser.
फर्स्ट
defendant number
2.
2. अच्छा ठीक.
मतलब 35 में 35 ही करना
35 में.
Yes, yes.
It has been submitted. नहीं ऐसे लिखिए. The defendant number 2 purchased the suit land from defendant number 4 through the power of attorney holder defendant number 3. Defendant number 2 के ब्रैकेट में लिख लेंगे लाला विवेक प्रसाद. Thus, Lala Vivek Prasad was the first purchaser and defendant number 1 was the second purchaser. With respect to the same suit property. The learned trial court framed the following issues for consideration. One is the suit maintainable in its present form or not? 2. Has the plaintiff any cause of action for the suit? 3. Is the suit barred by limitation, estoppel, waiver, accusance, and by the provisions of Specific Relief Act? 4. Is the suit barred by the Transfer of Property and Registration Act? 5. Is the suit barred by non-joinder and misjoinder of necessary parties? 6. Whether the description of the suit land is incorrect and vague. 7. Is the defendant number 3 has no right to execute the power of attorney with regard to the suit land. 8. Is the power of attorney executed by defendant is legal, valid, effective and admissible in law. 9. Is the defendant number 3 the nephew of deceased Alguram? 10. Have the plaintiffs got the right title, interest and possession of the suit land or not? 11. Is the registered sale deed number 1420 dated 3/3/2011 executed by defendant number 2 in favor of defendant number 1 is legally valid, operative and lawfully binding on the plaintiffs or not? 12. Whether the defendant number 4 has any right, title, interest to execute the sale deed number 5889 dated 10/11/2010 in favor of defendant number 2 or not. 13. Whether the plaintiffs has entitled to get any relief or other reliefs. Language भी ऐसा गलत लिखते हैं कि कुछ ये नहीं है. From the perusal of the issues framed, it appears that the issues were framed in relation to both the sale deeds, that is sale deed number 1420 dated 3/3/2011 and also sale deed number 5889 dated 10/11/2010. The first one executed by defendant number 2 in favor of defendant number 1 and the second was executed by defendant number 4 in favor of defendant number 2, which were in relation to the same property, same suit property, and were back-to-back settlements. However, admittedly, the sale deed number 5889 dated 10/11/2010 was not specifically challenged in the suit. This fact has been specifically pointed out by the learned counsel for the appellant to submit that the previous sale deed dated 10/11/2010 having not been challenged in the relief portion, the subsequent sale deed having been challenged, no relief could have been granted with respect to the subsequent deed, as the previous deed continued to remain intact and unchallenged. The plaintiff examined altogether 9 witnesses. PW1 was Sudama Singh, who was plaintiff number 2. PW2 was a formal witness. इसका ना लिस्ट बना लेंगे. PW1 Sudama Singh, plaintiff number 2. PW2 Barha Manji, a formal witness. PW3 Kokil Mehto. PW4 is Ram Naresh Singh. PW5 is Ram Narayan Singh. PW6 Paras Mehto. PW7 Krishna Singh, who is the plaintiff number 1. And PW8 is Ramji Singh. PW9 is also is the plaintiff number 3. Bhola Singh is plaintiff number 3. The documents, the documentary evidence were produced by PW7, 8 and 9. PW8 had exhibited Exhibit 4, the voter card, within bracket, Nirbachan card, bracket rules, dated 6/9/2017, and PW9 had exhibited Exhibit 7, the certified copy of the family list certificate number 56 and certified copy of the power of attorney number 3518 dated 8/11/2000, and the remaining documents were exhibited by the plaintiff number 1, who was examined as PWC. The list of documentary evidences on behalf of the plaintiff is as under paragraph 7 again. The defendants also examined altogether 8 witnesses. DW1, Dukhan Sahu is a formal witness who is the writer of the impugned sale deed number 1420, which was marked Exhibit A. DW2 is Rameshwar Singh, who is the defendant number 3. And claimed to be the nephew of Ayuba. Defendant DW3 is Baznath Singh, who is the brother of Taraknath Singh,
Yes.
Uncle of the plaintiffs.
uncle of the own
Plaintiff.
uncle of the plaintiffs,
Admittedly. Brother of the Vishwa, late Jogeshwar.
and son of late,
Brother of Jogeshwar.
and also brother of Jogeshwar Singh,
Jogeshwar.
Jogeshwar Ram,
Jogeshwar Ram Singh.
and son of late,
Son of Devnath. Sukhari Singh.
son of Sukhari Singh. DW4 is Ramkeshwar Singh, who is इनका क्या रिलेशन है DW4 का?
He is the uncle of DW3.
हाँ, who is the uncle of DW3, own uncle of DW3 and also the plaintiffs.
No, he is not the uncle of plaintiff. He is uncle of DW3.
DW3 is the
Rameshwar Singh.
DW3 is Bajnath Singh.
So DW defendant number 3, Rameshwar Singh.
ये उसकी बात है.
और
DW3 is Bajnath Singh.
Rameshwar Singh is DW2, and he is the Ramkeshwar Singh is uncle of DW2.
Okay. Ramkeshwar Singh is uncle of
DW2.
DW2. Or defendant DW2 within bracket Rameshwar Singh,
Who is defendant number 3?
who is defendant number 3. DW5 is Vijay Kumar Sinha, the defendant number 5.
There in the, because our story, our case is Albu was survived by one brother. So he is a cousin of Albu, this Ramkeshwar. Though uncle, but he say own uncle, cousin, मतलब दूर के रिश्तेदार.
ये तो डॉक्यूमेंट में इन सबके फादर का नाम एक ही
नहीं
है.
नहीं वो तो डिस्प्यूटेड डॉक्यूमेंट है सेल डीड वाला. That is a disputed
But
document.
that has not been challenged anywhere. तो dispute अब कैसे रहेगा? जैसे हमने challenge
लड़िए मत please.
That sale deed वाला से ये बोल रहे
नहीं,
इसीलिए
what I am
बोल रहे.
saying कि those documents which have not been challenged either by me or by him cannot be said to be disputed, but that is still existing.
Well, he says Ramkeshwar Singh, son of Ram Vriksh Singh, in his deposition.
Who DW4 who claims to be the son of Ram Vriksh Singh.
Yes.
DW6 is Lala Vivek Prasad, who is defendant number
4.
4.
Yes.
नहीं, defendant number 2.
Vivek Prasad is defendant number 2.
2.
Within bracket defendant number 2. And DW7 is Prashant Kumar Mandal, who is a formal witness. DW8 is the Assistant General Manager of the defendant number 1, namely Aditya Mehto. The following documents were exhibited from the side of the defendants. Exhibit A, salary number 1420. Exhibit B, power of attorney. Exhibit A by 1, salary number 5889. Exhibit C, rent receipt number 026757. Exhibit D, Khatiyan. Exhibit E and E by 1, 2 mutation slips. Exhibit F, certified copy of the order sheet. So far as the issue number 1 is concerned, the learned trial court was of the opinion that the suit was maintainable and the court had to find out as to who had the better title amongst the plaintiff and the defendant, and held that and decided issue number 1 in favor of the plaintiff, holding that in favor of plaintiff. With regard to issue number 2 dealing with cause of action, the learned court was of the view that the disputed property was transferred to various defendants and the plaintiff was claiming the property and therefore the rights of plaintiff was violated and consequently there was a cause of action, and decided this issue in favor of the plaintiff. With regard to issue number 3, the learned court held that the suit was not barred by limitation, estoppel, waiver, acquiescence, and by the provisions of Specific Relief Act, and held that the suit was and decided the issue in favor of the plaintiff. By deciding issue number 4, the learned court held that the suit was not barred by the provisions of Transfer of Property and Indian Registration Act. With respect to issue number 5, the learned court was of the view that all the necessary parties were joined in the suit and therefore the suit was not barred for non-joinder or misjoinder of parties. With regard to issue number 6, the learned court held that the description of land was proper, and this issue was also decided in favor of the plaintiff and against the defendant. By addressing the issue, after addressing the issue number 1, 2, 3, 1 to 6, the learned court referred to issue number 7 as to whether the defendant number 3 had the right to execute the power of attorney with regard to the suit land, and was of the view that this will depend on the issue of right, title and interest over the suit property. And held that right title and interest over the suit property. And while deciding other issues, it was held that the defendant had no right title and interest over the suit property, and therefore the defendant number 3 had no right to execute the power of attorney with regard to the suit land, and decided this issue against the defendant and in favor of the plaintiffs. With respect to issue number 8, the learned court recorded that the answer to issue number 8 was dependent on as to whether the defendant number 3 had the right to execute power of attorney. And since the power of attorney executed by defendant number 3 was held to be not legal and valid, therefore, defendant number 3 had no right, title and interest over the suit property. And it was held that, and it was also observed that by deciding issue number 9, it was held that defendant number 3 was not the legal heir of the owner of the suit property. Issue number 9 was essentially related to the core issue, that is, as to whether the defendant number 3 was the nephew of the deceased Albu Ram. The learned court decided issue number 9, white, paragraph 17, and held that defendant number 3 was not the nephew of Albu Ram, and consequently the power of attorney executed by defendant number 3 and all the transaction based on such power of attorney, including the sale deeds, were declared to be null and void. While deciding issue number 10, the learned court held that the learned court observed that the plaintiffs, that the witnesses of the plaintiff have fully supported the case of the plaintiff, and even the defendant had somehow supported the case of the plaintiff. And was of the view that the case was to be decided on the basis of preponderance of probability, and ultimately found that the plaintiff had better title over the property. The learned court again reiterated that defendant number 3 was not the nephew of Albu Ram, so the power of attorney executed by him was totally illegal and without any force of law. It was also observed that several documents have been produced by the plaintiff including the Panchnama, by which late Algu Ram had given power of attorney to late Yogeshwar Ram, by which Algu Ram had given permissive possession and right to enjoy the disputed land to late Yogeshwar Ram. Similarly, late Yogeshwar Ram also executed power of attorney in the name of Sri Krishna Kumar, who was the plaintiff of the case, marked as Exhibit 8. The learned court further recorded that although the said document was objected to by the defendant, but it was the opinion of the court that the society should respect the wishes of dead person. In this case, it had come on record that after executing the power of attorney, the executor Algu Ram had gone to his native village and never came back and died there, which showed that his last wish was to give the land to his friend, relative, late Yogeshwar Ram. So the power of attorney is to be treated as his last wish or as an unregistered will. And further observe that, on the other hand, Rameshwar Ram had not produced any single bit of paper or document showing that he was in any way related to late Algu Ram. The claim of Rameshwar Singh was falsified, that he was the nephew of the learned court also observed that the claim of Rameshwar Singh was falsified by Exhibit 9, and on the basis of Exhibit 9, the learned court came to a conclusion that Rameshwar Singh was the nephew of Ramkishwar Singh, because the father of Rameshwar Singh and Ramkishwar Singh were same, namely Ram Vriksha Singh, and Ramkeshwar Singh admitted and specifically stated that Radha Krishna Singh's father was Vriksha Singh. The learned court ultimately further discussed some more materials, including Exhibit 7, which was a genealogy, which was the alleged genealogy of late Algu Ram, said to have been issued by the Circle Office of Jagdishpur, where Algu Ram had died, which showed that he had only one brother, namely Jharur Singh, and there was no name of Radha Krishna Singh as the brother of late Algu Ram, which, according to the learned trial court, falsified the case of the defendant that Rameshwar Singh is nephew of late Algu Ram, due to which the learned court observed that the entire case of Rameshwar Singh failed. The learned trial court considered the case of the respective parties and discussed the materials, and ultimately held that the plaintiff had better title and This was also supported by the fact that the plaintiff was in possession of the suit property. Possession plaintiff का declared.
That is,
अभी भी है.
he is in possession of his portion of the land. His portion is not
Right.
disturbed.
By referring to section 110 of the Indian Evidence Act. The issue number 10 was ultimately decided in favor of the plaintiff and against the defendants. The issue number 11 was as a sequel to the findings recorded. The issue number 11 was also decided in favor of the plaintiff by holding that the registered CD number 1420 dated 3/3/2011 was declared as null and void and not legally binding upon the plaintiffs. So far as issue number 12 is concerned, it was held that the defendant number 4 did not have any right, title and interest to execute the CD number 5889 dated 10/11/2010 in favor of the defendant number 2, and it was also declared that the CD number 5889 dated 10/11/2010 in favor of defendant number 2 was null and void. And ultimately the suit was decreed in favor of the plaintiffs. कहानी खत्म? During the course of arguments, the learned counsel for the appellants have submitted that the point for determination in the present case would be सिक्स भी रखना होगा क्या? 6.
We have formulated question of law that should be taken straight away from here, from our appeal. Questions of law, in which the first is no document of title. So that was the
No.
Yeah.
Point for determination.
Yeah, point for determination is there in our appeal itself. Determination is different, but what we have formulated in the petition is important. That's the appeal.
Point of determination उसके तो अलग से कुछ नहीं लिखे हैं. आप तो सब ऐसे ही general लिखते हैं.
Issues, page
हाँ.
number 12, issues.
Page
Oh,
number-
sorry, sir. Our questions.
Issues आपने लिखा है. Point for determination बोल के तो आपने अलग से कुछ नहीं लिखा है इसमें. We had we had discussed it yesterday. Kindly recollect.
Yeah, that can be taken also.
Which
Yes,
can
yes.
we can take it from there.
7, 8.
हाँ.
This is how.
6 ये non-jointer के बारे में.
Non-joinder के
ये
बारे
क्या
में
issue?
point number 1, point number 6 I remember.
हाँ.
Non-joinder था. 7 को हम लोगों ने छोड़ दिया था. 8 was taken because there was forgery, allegation of forgery and fraud. Then from 7, 8, then from 9 to 13.
इसमें non-jointer आप किसका non-jointer बोल रहे हैं?
His जोगेश्वर राम के जो दोनों भाई हैं.
हाँ. Two brothers.
Yes, बैजनाथ ने बेचा है ना.
हाँ.
उनके जो सबसे छोटे भाई हैं उन्होंने तो बेचा
Third
है
case
5
में है ना?
decimal land. तीसरे में, थर्ड.
तीसरे में ना.
हाँ,
तो
तीसरे.
इस केस की
हाँ, इस केस में नहीं. He is in this
इस केस में non-jointer
he is
हटा
only
दें.
non-joiner because they are claiming everything through Jogeshwar Ram,
But the other.
but other
persons
brothers
not.
are not made parties. Other claimants,
Other brothers of Jogeshwar Ram.
yes, have not
and
been made parties because he is claiming inheritance
That's
from Jogeshwar Ram. So then those persons should have been made
During the
party.
course of argument, the learned counsel for the appellant has submitted that the point of determination in the present case would be the
Even
same
his father.
as issue number 1, 6, 8 to 11 and 13.
Even his father was alive. Even
Right. Yes.
Tarak Nath was alive. He was not made a party.
Yes, 1, 6, 8 to 11 and 13. Check
Yes,
it.
yes. 1, 11 and 12 we discarded because of repetition.
11
of
also you discarded.
discarded. Yes.
नहीं ये तो पंचनामा है 11.
हाँ पंचनामा not एक हम लोगों ने डिस्कार्ड किया था शायद 12
12 आपने
because that was
discard
probably superseded.
self acquired property.
Self acquired.
But 12
Yes.
हमने
Because that was
discard
an admitted position. Yes, yes. I
नहीं
stand
लेकिन
corrected.
इस केस में ना इश्यूज अलग हैं. इस केस में इश्यूज अलग हैं. 13 है इसमें और इसमें 14.
नंबर का थोड़ा सा
हाँ,
डिफरेंस.
तो इसमें इसको एक बार चेक करिए.
हम चेक. 35 का issue number 1 is issue number 1.
Maintainable.
Yes.
The necessary parties para number 5. Issue number 5.
Issue number 5
है ना?
barred by yes.
हाँ.
Non-joinder,
उसके
misjoinder.
बाद issue number 7.
Yes.
Then issue number
8 was discarded
is-
because this is about my power of attorney which I executed.
executed by defendant.
Yes.
Depends.
Yes.
That should be considered.
Okay, take it. Take 8 each.
8 also.
No issue. No issue. Yes.
7, 8,
Now then 9.
Nine.
Number 3 is the nephew
9
of
also.
9.
10,
10. Yes, 10.
then 11, 12.
12.
ठीक है? The point for determination in the present case would be the same as issue number 1, 5, 7, 8, 9, 10, 11
and 12.
and 12.
Yes.
Which were framed by the learned trial court. In addition, the learned counsel for the appellant has also submitted that whether the learned trial court could have set aside the sale deed number 5889 dated
Dated
10/11/2010,
Yes. Yes.
which was not specifically challenged
Challenge.
by the plaintiff. in
No,
the
it
suit.
should be this way. He should, whether he could set aside 3/3/11 in view of the fact that the previous sale deed was not challenged. That should be the formulation.
Okay. Whether the learned trial court could have set
Could
aside
have set aside 3/3/11.
the registered sale deed number 1420 dated 3/3/2011,
Yes, yes.
which was subject matter of the suit,
Yes.
in absence of any challenge to the registered sale deed number 5889 dated 10/11/2010,
Absolutely.
and whether the registered sale deed number 5889 dated 10/11/2010 could have been declared to be null and void when there was no specific challenge in the prayer portion of the suit. Yeah, yeah.
Yes. Yes.
These are two additional
Correct.
issues.
Rather, the Rameshwar Ram was made the pro forma defendant, and they have admitted that there is no prayer against Rameshwar Singh. It is their admitted position.
This would be, और जो ये वाला जो होगा आपका, जो दूसरा वाला जो केस होगा, इसमें होगा आपका इशू नंबर 1677 में 1, 6, 8 to 11 and 13.
नहीं, नहीं, मेरा
इसको ध्यान रखेंगे, है ना? 1, 6, 8 to 11 and 13. और साथ में ये जो एडिशनल इशू है इसमें, ठीक है?
Yes.
तो याद रहेगा? तो ये दोनों का तो फैक्ट्स एक ही जैसा हो गया.
Almost identical. Certain differences are there in their deposition. That's it. That's it.
4 बज गया है.
Right.
अब इसको टाइप को क्या आने दीजिए.
Yes.
आपको आने की जरूरत नहीं है.
I'm so grateful. If required, I'll appear online just to hear.
Well, just you.
I'll do.
Well, you can appear online just to hear, and if there is any error, he is
Yes.
well versed with the entire subject.
Yes.
I think ये लोग सभी को सारी बातें पता है. कुछ एरर आपको
No, he is more competent than me.
कॉम्पिटेंस
जब
का
हम
बात
आते हैं
नहीं है.
तो ये लोग हमको आगे
It
कर
is
देते
not a
हैं.
matter of competence. आप सीनियर हैं तो
Yes.
आप certainly we assume that you are more competent. कोई इनके competence को undermine नहीं कर रहे हैं, लेकिन fact के बारे में जो पकड़ एक instructing counsel को होता है वो senior को भी नहीं होता.
Yes, absolutely, absolutely.
Senior. ठीक है. Pose this case for further dictation on कोई भी एक तो दे दे. सीधा लिख दीजिए ना. Pose this case for further dictation.
Okay.
Dictation of the judgment has commenced. Pose this case for further dictation on Monday.
Monday. Absolutely.
Monday?
Absolutely. Possible.
Monday नहीं, Monday 2:15 हम लोग केस रखे. Monday, Tuesday 2:15 हम लोग का केस रखा हुआ है. उस दिन नहीं.
Next Wednesday.
Next Wednesday.
Next Monday.
नहीं, Monday तो रखा हुआ था.
Monday already रखा.
No, no, I'm not talking about 60. The next week, ना?
हाँ next week.
After next week. तो Monday can be.
नहीं Monday to Monday नहीं.
अच्छा,
लंबा
Monday.
नहीं जाएगा. फिर
हाँ.
इतना continuity में.
हमने
नहीं.
सोचा कि वो 7 days का चक्कर है.
नहीं.
It's okay.
Next Wednesday को तो कुछ ऐसा नहीं रखा.
18th.
18 को टाइम नहीं दिया हुआ लेकिन सप्लीमेंट्री में 3 केस होंगे.
वो कोई बात नहीं. इसको तो हम लोग करेंगे.
और मंडे के लिए 2 केस है जो 15:30 के लिए.
2:15 बजे कर रहे हैं. 2:15 बजे.
So,
At 2:15.
yes.
16
नहीं Wednesday. Wednesday. ठीक है.
That would be 18th.
तब तक ना ये तीनों का ये जो पोर्शन है ना ये कंप्लीट हो जाए.
हाँ.
क्योंकि साइमल्टेनियसली नहीं चलेगा तो गड़बड़ हो जाएगा.
Super.
पास ओवर
पास ओवर है. किसका है पास ओवर?
पास ओवर केस आइटम 23.
Who is appearing? Mr. Ravi Prakash was here. I saw him just now. Judgment of reversal. बताइए. It's a judgment of reversal.
Yes.
Okay. And you are the
I was
defendant.
plaintiff. I was plaintiff.
You were plaintiff. Okay. You are the plaintiff. What was the suit about?
For declaring the right title and possession, restoring the possession of the suit.
With respect to possession also there is a
Yeah.
judgment of reversal. The claim of adverse possession was declined by the trial court.
By the trial court as well as by the first opinion.
The
Both.
claim of adverse possession has
Yes.
been declined.
The claim of the defendant, there are basically the defendant the raised proof.
First your claim.
My claim is so far as the I have filed this suit stating that in the year of 1956 the land has been settled to me by the Bhudan Yagya Committee, dependent number 3, in the year of 1956. It's initially belonged to the Chota Nagpur Maharaj, who the gifted the land to the Bhudan Yagya Committee, and thereafter it has been settled to me in the year of 1956. And since thereafter, I came in possession of over the land.
All rent receipts issued
Yes, my lord, the
since 1956.
1950.
What is your oldest rent receipt?
My lord, rent receipt is, my lord, 68 on something. My lord.
Okay, anyways, according to you, you claimed settlement by way of Mudan Yagna
Mudan.
Committee and then possession.
Then possession, my lord, I constructed the well in the suit line, my lord, and thereafter, my lord, I was in peaceful possession. My lord, what has happened, my lord, in the year of 1961, the landlord, my lord, the Chota Nagpur Maharaj, my lord, registered, executed a sale deed in the name of defendant, 1961. And thereafter, my lord, he started creating trouble, my lord, and he had, my lord, the tried, my lord, in the year of 1970 also, my lord, to dispossess me. Ultimately, my lord, he succeeded in the year of 2000, my lord. Forcefully, my lord, I was, my lord, the dispossessed. Then, my lord, the 2002, my lord, I filed, my lord.
Yes, he executed a sale deed after he handed over the property to
Yes,
Bhuban.
my lord. Once, my lord, he gifted the property, my lord, he has no right to, my
The
lord,
gift was by what means?
my lord, that has not come, but dependent number 2, who is, my lord, the Budan Yag committee, my lord, he appeared, he filed written statement, and he supported my government, my lord, stating that it has been settled to me, my lord. He committee acquired the land, my lord, by way of gift did, my lord, by the Chota Nagpur Maharaj. And thereafter, my lord, he settled the land of other person also, my lord, but so
And
far
this Chota Nagpur Maharaj was represented in the suit.
no.
He was not made party. He was not
Because,
made
my
party.
lord, he has never challenged, my lord, this land, that it was never gifted. And now, the main thing is, my lord, so far as the registered deed is concerned, my lord, on the basis of which, my lord, the defendant claim to be the owner of the land, my lord, that is, my lord, that first appellate court also, my lord, negative his claim, my lord, on the ground that it was with respect to Khata number 1, whereas, my lord, the suit land belongs to Khata number 81.
Oh,
And
there is a description
yes,
difference also.
that's why, my lord, his right title on the basis of that sale deed was negative by the trial court as well as by the first appellate court also. And so far as the adverse possession is concerned, my lord, that has also been negative. Saying
So
that
why was there an order of reversal?
that is, my lord, certainly, my lord, he's saying, my lord, that I have produced, my lord, the certified copy of the settlement deed. Whereas I have pleaded, my lord, my original copy I have handed over to my advocate clerk, my lord.
ये
It
सब
was
रोज का हर केस का कहानी है. एडवोकेट क्लर्क को दे दिए, गुम हो गया.
actually,
हर केस में यही सब कहानी.
इतना जानता नहीं है, मुझे विश्वास में करके दे देता है.
तो सर्टिफाइड कॉपी आपने प्रोड्यूस
हाँ.
किया.
So on that ground, my lord, this is required to be argued.
सब्सटेंशियल क्वेश्चन ऑफ लॉ क्या बना है?
My lord,
बताइए.
the trial court.
नहीं, आप खुद क्या प्रपोज कर रहे हैं?
My lord, the
ध्यान से प्रपोज करेंगे, नहीं तो क्या होगा? कोई भी ऐसा फाइंडिंग ऑफ फैक्ट आ जाएगा तो आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ डिसाइड भी आपके फेवर में होकर भी आप केस हार जाइएगा. बताइए कौन सा सब्सटेंशियल क्वेश्चन ऑफ लॉ?
you know, there are one thing, so whether the suit is barred by res judicata in view of the earlier order passed under CNTA for restoration of possession. Appellate court said, you know, earlier, you know, the 145 proceeding is there, as well as, you know, the this my appellant, you know, he has also filed a case under CNTA. That was also, you know, dismissed, you know, it was not charged.
Is it tribal? It was
Tribal.
dismissed on merits.
Yeah, no, not merit, on the report of the CO, it was dismissed.
Adjudication तो नहीं हुआ ना.
No, adjudication. Even then, it cannot create, the res judicata so far as the proceeding in the civil court is concerned.
तो रेस जुडिकाटा बोला है क्या?
ये फाइंडिंग में दिए हैं फर्स्ट. Although it is not, but I am the one of the substantial question of law is there.
बताइए नंबर बताइए.
Yes, whether the suit is
सीरियल नंबर.
जजमेंट
ये आप अपना सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाए है ना, 1 दर्जन से ज्यादा बना दिए, आप बताइए कौन सब्सटेंशिएट करिए। 1 दर्जन सब्सटेंशियल क्वेश्चन ऑफ लॉ, वेरी डिफिकल्ट।
एक सीरियल नंबर 10
देखिए आपका कोर इशू कौन सा था, इशू नंबर 3 and 4, करेक्ट?
मेरा कोर इशू तो 4 है, इशू नंबर 4। So far as 3 is concerned, मतलब that is bar by limitation or adverse possession. It was claimed by the
डिफेंडेंट। तो कोई एडवर्स पोजीशन का फाइंडिंग तो डिफेंडेंट नंबर 3 के इशू नंबर 3 डिफेंडेंट के फेवर में डिसाइड हुआ है क्या?
नहीं, वो दोनों निगेटिव हो गया। ट्रायल कोर्ट अपीलेट फर्स्ट अपीलेट कोर्ट भी बोला है कि ही इज नॉट इंटाइटल्ड
अगेंस्ट द डिफेंडेंट।
यस नॉट द
फर्स्ट अपीलेट कोर्ट में
हम कहाँ पर हम बता दें पेज लॉर्डशिप में कैन यू सी पेज 36 पेज 36 हम लोग फोर्थ पैराग्राफ इन द मिडिल अपार्ट फ्रॉम द एबव एज लॉर्डशिप
हाँ
apart from that it is also settled principle of law that no one can blow hot and cold in the same breath. In the case in hand, the defendant who on one hand has
इशू नंबर 3 का तो कहानी खत्म हो गई, ठीक है? अब बचा इशू नंबर 3 का,
issue number 4
इशू नंबर 4 से
that has been reversed by the first appellate court. इनका पूरा फाइंडिंग पेज 29 onward. पेज 32
दिखाइए।
पेज 32 का सेकंड in the light of the aforesaid finding that the plaintiff has not been under possession of the suit land and view of the specific earlier finding that the plaintiff has no valid right title or interest over the suit land, I do not find the plaintiff to be entitled for possession of the suit land. For the very reason, he is also not found entitled for recovery of the suit land. There are various it starts from page 29 the finding is there the details more the discussion is there
और ट्रायल कोर्ट का फाइंडिंग
trial court का finding page 45 starts page 45 and particularly paragraph 13 page 48 may I read more paragraph 13 page 48 thus the aforesaid discussion are concluded that the plaintiff has got right title interest over the suit land on the basis of exhibit 2 that is not the settlement which is a settlement of suit land in which Vidan Yek committee settle the suit land to the plaintiff. The defendant number 2, who is a Vidan Yek committee in this suit, has said in his written statement that the suit land was settled to the plaintiff. On the other hand, the defendant number 1 has claiming the right title interest on the basis of the sale deed and adverse position. But the defendant number 1 is filed the sale deed which is marked exhibit B. In this case is not related to the suit land because it is for the khata number 1 and the suit land is situated in khata number 81 of the defendant.
सेकेंड अपील नंबर 74 of 2017. This appeal has been filed against judgment dated 29/9/2016, passed by learned District Judge Roman Court Gumla in title appeal number 6 of 2009, whereby the learned First Appellate Court has reversed the judgment dated 24/2/2009, passed by learned Munsif Gumla in title suit number 32 of 2002. The learned counsel for the appellant has submitted that so far as issue number 3 regarding adverse possession is concerned, the said plea has been negatived by both the courts by concurrent findings. So the core issue which remains is issue number 4 as to whether the plaintiff has right, title and interest over the suit property. The learned counsel has submitted that the learned trial court, while considering the issue number 3 and 4 together, has clearly recorded finding in paragraph 13 that the suit property claimed by the defendant was different from the suit property involved in the present case, and after detailed discussion the right, title, interest of the plaintiff was declared. But the learned First Appellate Court, while reversing this finding, has not considered this aspect of the matter and has not, and accordingly the appeal be admitted on following substantial question of whether the learned First Appellate Court, while reversing the judgment with respect to issue number 4, has failed to consider, has committed perversity and has also not dealt with the reasons assigned by the learned trial court while decreeing the suit in favor of the plaintiff. ठीक है? आपको कुछ बोलना है?
Plaintiff claiming that the suit land, he was bought the land after donated by the.
नहीं, वो तो आपको सुनेंगे,
हाँ.
लेकिन और भी ये जो बोल रहे हैं कि
मेन पार्टी इसमें महाराजा हैं, इनको पार्टी बनाया नहीं गया. Without him cannot be decided such kind of cases.
That we will see. लेकिन ये जो सूट का प्रॉपर्टी जो आपका डिस्क्रिप्शन है और इनका सूट लैंड का जो क्लेम है वो अलग अलग है, कुछ फर्क है दोनों में कि नहीं है? वो एपेलेट कोर्ट ने डील नहीं किया.
एपेलेट कोर्ट भी नेगेटिव किया. एपेलेट कोर्ट भी बोलते हैं कि बोथ आर डिफरेंट एंड दैट्स व्हाई मतलब द राइट टाइटल वाज आल्सो नेगेटिव बाय देम.
Moreover, Lordship, no sheet of paper regarding.
देखते हैं, वो तो हियरिंग के समय आएगा ना. ठीक है, आप किन की तरफ से हैं रिस्पॉन्डेंट? ओनली वन, बाकी को नोटिस से आएगा?
नहीं, दो का तो जो स्टेट से दो का तो एक्सेप्ट हो गया पेपर पब्लिकेशन.
पेपर पब्लिकेशन कर दिए.
हाँ, कर दिए थे, लास्ट ऑर्डर में हो गया.
मेरा रजिस्टर्ड डीड है.
हाँ ठीक है, देखिए
वो क्लियर नहीं कर रहे थे आफ्टर सेवरल नोटिस देन लास्टली पेपर पब्लिकेशन.
पेपर पब्लिकेशन सिर्फ दो का हुआ है.
एक की तरफ से एफआईआर कर रहे हैं और 3 इज स्टेट.
कॉन्डोनेशन ऑफ डिले पर हुआ है, लेकिन अब तो अपील का फिर से आपको पेपर पब्लिकेशन करना पड़ेगा. ठीक है ना? लेकिन ऐसे सीधे पेपर पब्लिकेशन का ऑर्डर नहीं करेंगे. क्या करेंगे बताइए? एडमिट होने के पहले पेपर पब्लिकेशन हुआ है तो कंडोन द डिले. कुछ तो प्रोसेस आपको करना पड़ेगा. द रेस्पोंडेंट नंबर, रेस्पोंडेंट नंबर 1 एंड रेस्पोंडेंट नंबर 1 डेट दिखा रहा है.
उनका बेटा है.
सब्स्टिट्यूशन हो गया है? हो चुका है? अच्छा, Respondent number 1 and respondent number 3 are represented before this court and therefore no notice need be issued. So ये बिहार भूदान यज्ञ कमिटी गुंडा एंड सिमडेगा ये तो एग्जिस्ट कर रहा होगा, तो आप इंस्ट्रक्शन नहीं ले सकते.
स्टेट में जो स्टेट
थोड़ा देखिएगा भाई, ये तो ऐसा बॉडी है, इट्स अ परमानेंट बॉडी. अब इनके लिए पेपर पब्लिकेशन कराना तो ठीक नहीं रहेगा. Anyways, let notice be issued to the respondent number 2 through the concerned police station, for which requisites be filed by the appellant within a period of 1 week. Let the records be called for from the concerned court. वही आपका जो substantial question of robbery admit कर रहे हैं, ठीक है? बताइए कब करना है? Pose this case on 9th of July. Let this order be communicated through fax.
I have to hand over the notice to the state council.
नहीं, आपको नहीं, यहाँ पे आप फाइल कर दीजिए, यहीं से चला जाता है. The counsel for the state is directed to seek instructions and file affidavit of service of notice upon respondent. ठीक है? Prior to the next date.
क्लियरेंस दे दीजिए.
कोई ना कोई जरूर होगा, ऑफिस शिफ्ट हो गया होगा, चाहे कुछ भी होगा. Orders.
On the heading for orders, item 10, first appeal 47 of 2015.
Yes.
Simultaneously office notes.
Okay.
Notices were issued to the respondent legal year, the proposed legal years of respondent local, but they did not receive the notice.
Refused.
Refused नहीं लिखा हुआ, did not receive the notice.
किसमें गया था नोटिस? आईए में.
आईए में सब्स्टिट्यूशन हो गया.
However, on going through IA number 659 of 24, it appears that proposed legal year number 1A and respondent number 2A
Did not receive their notice.
both are same person.
Partition suit. सब relative.
कौन से ऑर्डर से नोटिस किया था? 25/2. देखिए, FA number 47 of 2015, the learned counsel for the appellant, by referring to the service report, has submitted that the legal years and successors, the proposed legal years and successors whose name has been mentioned in IA number 659 of 2024 have not received the notices issued by this court pursuant to order dated 25/2/2025. And the return notice does not show any endorsement of refusal, but it has been served by pasting. Considering the aforesaid submission, let fresh notice be issued
No,
in
this
the
is see there.
issued in the interlocutory application being IA number 659 of 2024 to the proposed legal heirs and successors of the deceased respondent number 1, 2, 5, 6, 11, 12, 14, 19 and 25 through the concerned police station, for which requisites be filed
3 weeks
before
of-
this court within a period of 2 weeks.
2 weeks. Okay.
Close this case on 31st July awaiting service report. वो लोग पुलिस वाला जाता है तो लोग थोड़ा केयरफुली उसको
इंटेंशनली नहीं दे रहे हैं
शांति से रह रहे हैं इसीलिए नहीं दे रहे.
Item 11, FS 73 of 2020.
Yes.
Heading जो है wrongly है, especially hearing मैम की notice में.
It should have come for hearing.
Yes.
Mine is item number 12.
Record आ गया.
Yes, yes.
क्या है टाइटल सूट है क्या है?
I'm not in this matter.
Oh, you are not there. in this. As reported by the learned court master, this case has been wrongly listed under the heading for orders. It ought to have been listed under the heading for hearing.
Yes.
Let this
ये 73 173.
ये क्या है?
Serial number.
हम कौन सा समझे? फर्स्ट अपील लेके कि सेकंड अपील?
Yes, first appeal 73.
तो ये आप क्या पकड़ा दिए हमको? सेकंड अपील 173?
Sorry.
ये फर्स्ट अपील 73 का ऑर्डर है. Let this matter be listed under appropriate heading. Specific of balance. Let this matter be listed for final disposal. Record आ गया इसका?
नहीं,
हाँ?
नहीं.
तो इसका तो ऑफिस नोट भी आपने देखे होंगे. आ तो क्या है kept below?
Yes.
For final disposal on next Thursday. Next. Applicant absent.
Item 12, second appeal 173 of 2022.
बताइए.
Substitution applications.
Substitution. Who has expired?
One number 5.
Are you representing?
The last one.
Respondent number 5. When did he die?
We had to prepare. We had to file the substitution application.
When did he? Oh, he has expired, but
Yes.
you have not filed your substitution.
We have not filed it yet.
Was it reported earlier?
Yes, you know.
That
the
when?
last- the
When?
last occasion
When was it reported that he is dead?
on 27
Of?
March 2020. We were directed to file substitution application.
डायरेक्शन का क्या जरूरत है? मत फाइल करिए, अवेट कर जाएगा, उसमें क्या दिक्कत?
Seeking some time to file. And you know,
27/3 को it is already reported that he is dead.
yes, sir.
कितने दिन में आप सब्स्टिट्यूशन फाइल कर सकते हैं?
For the 2
बताइए.
weeks time. For the 2 weeks time.
30/1 का ही नोटिंग है that he has died. तो अवेट तो ऑलरेडी कर लिया. Anyways, आप देख लीजिए. essay number 173 of 2022. Counsel for the appellant prays for adjournment. Post on 25th of August. रुक जाइए. Post on 6th of October.
So far as respondent number 9 is concerned, notices were issued, but we could not file the requisite on the present and current address of respondent number 9.
क्या हुआ इसका?
We couldn't file the requisites.
क्या करें हम? नहीं किए तो
Paper publications.
पेपर पब्लिकेशन.
Respondent number 9 is the chairman, Jharkhand Bhudan Yagna Committee, head office at so and so, but it is not the present and current address. That noting is also there. The requisites has not been filed just because we couldn't get the present and current address.
आपको जो करना है करिए, तब तक आप अपना सब्स्टिट्यूटेड जो भी आपको नोटिस के लिए आपको पिटीशन फाइल करना पड़ेगा ना उसके लिए. लेकिन ये भूदान यज्ञ कमेटी का क्या ऑफिस बंद हो गया है क्या? फाइंड इट आउट. ऐसा तो नहीं होगा कि ऑफिस बंद हो गया.
Item 13, FS 70 of 2024.
Yes, please. What is this? PC सिन्हा. आपका नाम है ना PC सिन्हा? आपका फर्स्ट हाफ में कोई मैटर में मेंशन हुआ था? PC झा के नाम से. ऐसा भी कोई है क्या PC झा?
पीसी क्या है?
ठीक. और ये क्या हुआ?
1, 2, 3 1 and 2 में पर्सनली सर्व हुआ है और 3 तो हस्बैंड हुआ है. रिस्पोंडेंट नंबर 4 भी है ऑन रैंक पिटीशन एंड लिमिटेशन पिटीशन एलसीआर में है.
रिस्पॉन्ड नंबर 4 कौन है कोई?
काफी बना हुआ करेक्शन हुआ है मैडम. तो दूसरे पेज पर पेज नंबर 2 पर
कौन है रिस्पॉन्ड नंबर?
हुआ है.
आपके इसमें तो ओनली नंबर 3 तक है. रिस्पॉन्ड नंबर 4 तो है नहीं. कहाँ से बोल रहे हैं रिस्पॉन्ड नंबर 4? फ्रॉम वेयर?
पेज नंबर 2 में आपके पेज पर
कौन सा पेज नंबर 2?
मेरे पिटीशन का
मेन पिटीशन में सिर्फ रिस्पॉन्ड नंबर 3 है.
पेज नंबर दूसरे पेज पर
कौन सा? उसके बाद भी कोई पेज में पार्टी पोजीशन लिखाता है क्या?
कौशल्या देवी, भवानी मातो, मधु मातो एंड साधुन देवी.
साधुन देवी तो है. कौशल्या देवी डिलीट हो गया है 10/4/2024 को.
सॉरी सर्व हो गया.
FA number 70 of 2024. As per the office note, the notice upon respondent number 1 and 2 has been personally served. Respondent number 3 has been served through her husband. Considering the office note, the notice has already been served. कोई appear नहीं हुआ है.
नहीं आपके वकालत नामा तो नहीं है.
But nobody has entered appearance on behalf of respondent number 1 to 3. The records from the concerned court has also not been received. डिले कंफर्म कर देते हैं. आपका क्या करना है?
619 days. 619 days.
आज एक्सेप्ट किए ना वैलिड. परसों रख. Let this matter be posted day after tomorrow for consideration of IA number 3390 of 20.
Item 14, first appeal 157 of 2024.
Order number 5, 7/40/25. There was direction for issuance of notice upon respondent number 8 on present corrected. But during the sending notice, the respondent number 8 has appeared, so notice could not be filed. Yes.
Are you appearing for respondent number 8?
8
Plus 5,
8 is for another advocate, Mr. Chatur Prasad Singh.
plus from some another advocate as well.
Yes.
Okay, has appeared?
Yes.
Okay.
By filing Wakalat.
Notes so far respondent number 5, 10 and 12. The service report says notes
5, 10,
10
and
and 12.
yes.
The service report says so far 5 is not that he is trespass. 10 minutes, the elder sister has received the notice.
12.
At 12 not he personally received the notice. But all other co-sharer of the property words from him. Respondent number 1 has purchased the property.
तो respondent number 5 का क्या करेंगे?
इंस्ट्रक्शन दे देते हैं और फ्रेश नोटिस तो पेपर
10
पब्लिकेशन
को accept
5
कर
minutes,
सकते?
10 and 12 by
10 भी accept. पहले first appeal number 157 of 2024. As per the office note, सबका appearance लिखिए please. Respondent number 124, 6, 7, 9, 11, 13 to 15 have already appeared by filing wakalatnama. The notice, the notice upon respondent number 10 has been received by her elder sister, and respondent number 12 has received the notice personally. Considering the fact that notice has been served either personally or through close relative, notice upon respondent number 10 and 12 is accepted as validly served. So far as respondent number 5 is concerned, it has been reported that he is not present. The counsel for the appellant has also submitted that since respondent number 8 has already entered appearance by filing wakalatnama, therefore he did not file any requisite. Considering the submissions, no notice need be issued to respondent number 8 as he has already appeared by filing wakalatnama. Counsel for the appellant prays for some time to take steps for service of notice upon respondent number 5 at his present and correct address, or to file an appropriate petition for substituted service of notice.
Yes, because not probably I started my class whether he has appeared in this because his trespass is so that I am asking.
Then he will
So,
file an appropriate
yes,
application
yes.
that he may not be noticed.
Yes.
Substituted
Yes.
service of notice or any other
Yes.
interlocutory application for the needful. Correct?
Yes.
Pose this case on. बताइए कब रखते?
25 को भी रख सकते
25 को रखें? Post on 25th.
हैं पब्लिक
Item 15, FA 61 of 2025.
While order dated 3/4/2025 and also notices for the court upon the respondent and also as per the office report 126 appeared
I am
to
appearing on behalf of respondent number 126.
1 to
so
6.
far as
Okay.
respondent
7
served through his father.
order. 8 served through his mother.
As per the report
9 has
report to which time it is
देखिए FA number 61 of 2020. Respondent number 126 has already entered appearance. Counsel for this respondent is present. Respondent number 7 and 8 has been served through his father and mother respectively. Accordingly, service of notice upon respondent number 7 and 8 is accepted as valid. Respondent number 9 has been reported dead. Counsel for the appellant, please for time. How much time?
2.
Is respondent number 9 related to respondent number 1 to 6?
No, Your Honor. They are the performers.
Post on 9th of July? Yes.
My lord, in the hearing, my lord, first case is the next, but time has elapsed.
कौन सा first is?
Item 1 of hearing matter.
आपको करना है? चलिए करते हैं। लाइव करिए।
नहीं हम तो कर नहीं ऐसे नहीं
अदर साइड कौन है?
इसको कल रख दीजिए।
अगर आपको आज करना था ना तो
हाँ।
सुबह 10:30 बजे बोलना। उठते समय आप बोल रहे हैं कि हियरिंग टेकअप नहीं
हम
हुआ,
सोच
एज इफ कोर्ट का बहुत बड़ा गलती हो गया है
नहीं
कि हम नहीं
सोच
टेकअप कर पाए।
हम सोच रहे
आप सोच रहे थे कि टेकअप हो जाएगा?
नहीं अगर नहीं
बहुत
होगा
गलत
तो
असेसमेंट है आपका
अगर
कोर्ट
नहीं
का।
होगा तो हम बोले हमको मालूम था कि माय लॉर्ड टेक्स एम्पल
Takes
केयर
own time and a very slow court.
नहीं स्लो नहीं अब हमारा सुनिएगा तो दिस इज द वे ए सिविल अपील शुड बी है
अब अगली बार होगा जब होगा।
इसमें मिलट 19 तारीख को एग्जीक्यूशन में बाय वे ऑफ लास्ट चांस हमको टाइम मिला
नहीं आप मेंशन नहीं किए सर, अगर आप मेंशन करते तो हम जरूर आपका केस टेकअप करते, ऐसा नहीं है। अब
ये
आप
ठीक है।
उठते उठते बोल रहे हैं कि कोर्ट नहीं केस टेकअप कर पाया।
ये तो हम नहीं कह रहे हम कह रहे हैं कि कोई डेट फिक्स कर दिया
डेट तो कोई केस ऐसा है जिसमें डेट नहीं
नहीं
करता है।
215 में कर दिया जाए
हो
18
जाएगा।
तक
अगले
कोई-
अगले हफ्ते अपने से आएगा। आप कुछ अपना
तो
अदर
एक-
साइड अपीयर हो गया है।
हाँ हाँ जी अपीयर कर गया है फाइनल हियरिंग है एंड yesterday I have taken his consent also he
तो
said
कंसेंट लेके आप 4:45 बजे मेंशन करेंगे तो
नहीं
इनह्यूमन हो जाएगा ना मेरे लिए।
हम कभी भी ऐसा बात बोल सकते हैं कोई डेट 18 तक में कोई डेट
अपने से आएगा।
तो उसी दिन कोई एक टाइम 12:30 बजे का फिक्स कर दिया जाए
4:30 बजे के बाद किसी का एब्सेंस भी रिकॉर्ड नहीं कर सकते। अगर रहते तो हम कुछ ऑर्डर कर देते।
दिस इज
लेकिन
माय स्टेटमेंट कि कंसेंट हैज बीन टेकन
आपका स्टेटमेंट को हम ऑनर करते हैं लेकिन ट्रांसलेट नहीं कर पाएंगे राइटिंग में। वो
मेरे-
नहीं है अदर
मेरे स्टेटमेंट को लीजिए
अपने से आएगा कुछ।